if you don't mind recording. Good morning, everyone. My name is Meg Viss, and I'm the Outreach and Information Assistant at Seniors NL. And we would like to welcome you to this week's Let's Talk About the importance of having a will and an enduring power of attorney. We're going to start by acknowledging, we're going to start by me putting up sharing my screen with you is what we're going to do. So there you go. And I'm just going to hold on, slideshow from beginning. There we go. We're going to start by acknowledging the United Way and their support of our efforts. They allow us, because of their support, to offer this weekly Let's Talk and Just Ask sessions to help make it possible for the opportunity to share so many of these important presentations with you. So before we begin and introduce today's presenter, there are a few housekeeping items. I'm going to ask if everyone could mute your mics to block all outside noise. Captioning is available at the bottom of the screen. If you have any questions or comments, please put them in the chat. We also have a number of questions that came in upon registration, and all of those will save until the end of the presentation. We are recording, and that recording will be available to you probably later today or tomorrow once it's been uploaded to YouTube, and we will send that out to you by email. And if you have any suggestions on presentations for the future, we would love to hear from you and appreciate if you could send those to Mary E at seniorsnl.ca. Also, feel free to give us a call at 737-2333 local or 800-563-5599. Share your suggestions. And one additional thing, we would like to welcome Danica Philpott. She is our ASL interpreter for this session. Danica has been pinned to the top right corner of our screens. For anybody who would like to increase her real estate on your screen, meaning is she larger or smaller, you can go to the top of your screen. You'll see a video options. And you click on video options, scroll down and click on side-by-side mode, and then choose side-by-side speaker. And then you're going to see a cursor and a little gray line between our pictures and the content on the left. And you can just slide her back and forth until you get the size that you want. We've also put these instructions in the chat as well. I apologize if I've gone too quickly through it, but it's there for you. And I'm going to ask Barb if she could allow us to acknowledge the land that we live on.
We respectfully acknowledge the land on which we gather as the ancestral homelands of the Beothuk, whose culture has now been erased forever. We also acknowledge the land of Ukta-Hunguk as the unceded traditional territory of the Beothuk and the Mi'kmaq. And we acknowledge Labrador as the traditional and ancestral homelands of the Innu of Nitassinet and the Inuit of Nunavut and the Inuit of Nunatuavut. We recognize all First Peoples who were here before us, those who live with us now, and the 7 generations to come. As First Peoples have done since time immemorial, we strive to be responsible stewards of the land and to respect the cultures, ceremonies, and traditions of all who call it home. As we open our hearts and minds to the past, we commit ourselves to working in a spirit of truth and reconciliation to make a better future for all.
Thank you, Barb.
Welcome.
So today we're going to be talking about, well, actually, our presenter will be talking about the importance of having a will and an enduring power of attorney. When you registered, we asked if you had any of these legal documents. So I'm going to share with you the results of that on a percentage. So do you have a will 39% said yes, 61% said no. Do you have an enduring power of attorney? 16% said yes, 84% no. And we also asked about an advanced healthcare directive. 19% said yes, and 81% said no. We won't be talking about the advanced healthcare directive today because we are going to have actually 2 sessions on the advanced healthcare directive. And that will be in the very near future, and we'll let you know about that. So what I would like to do now is introduce you to our presenter, Kirsten Morry. Kirsten is the Legal Information Officer at the Public Legal Information Association of Newfoundland and Labrador, a mouthful which we refer to lovingly as PLIAN. Kirsten has worked in that office in this role since March of 2020. Oh, that's a special date. In that role, she does her best to answer client questions about various legal topics every day. She holds a Bachelor of Arts from Memorial and a BCL LLB from McGill University. Outside of work, Kirsten enjoys embroidery, swimming, and trivia, and she appeared on an episode of the quiz show Jeopardy in 2018. So I am going to stop sharing. And I'm going to pass this over to Kirsten. And as I mentioned, she'll be happy to do to answer your Q&A at the end of the session, and drop it into chat. And we'll also revisit the ones that you sent to us upon registration. Kirsten.
Hey. Hi there.
Hi.
Good morning, everyone. So I'm sharing my slide presentation here now, and I'm just going to go into presentation mode. Just a second here. So thank you so much, Meg, for that introduction. Today, I'm looking forward to explaining some of the ins and outs of wills and estates and powers of attorney. So these are very important topics, and of course, they become more relevant as time goes on in people's lives. These are documents that both relate to organizing your property. So a will is about what will happen after you die, whereas a power of attorney is a little different. That's a document that can enable someone else to make decisions about your property while you're still alive, but if you don't have the capacity to make those decisions yourselves. And we'll talk a lot more about what capacity means as the presentation goes on. Now, just a little bit about what we'll talk about today. I'll just discuss what my organization, PLIAN, does. And I would certainly encourage you to get in touch with us in the future. Talk about wills and powers of attorney in that order. I also have a little bit of specific considerations to think about if you have real property, so land and houses. And I'd also like to help you guys get a sense of why it's important to have a will and a power of attorney in place. What are the benefits to getting these things organized? So what is the Public Legal Information Association of Newfoundland and Labrador? We're a nonprofit organization. We're not a law firm. Our goal is to educate Newfoundlanders and Labradorians about the law and increase access to justice in Newfoundland and Labrador. We have an office in St. John's in the Merchant Tavern building currently. And we also have an office in Happy Valley Goose Bay, where my colleague Shirley White works. And we started that office in the spring of 2020. Now, our services include presentations like this one, so all sorts of education and information services to the public and partnerships with lots of organizations. But we also operate a legal information line. And so that's my job in the day-to-day. I answer questions from the public about all sorts of areas of law. I can't give legal advice, and that's an important distinction for us. But I do provide all sorts of information that can help people make decisions in their lives. Our services include what I just mentioned. We also have my colleagues who operate the Journey Project, and they provide services that are specific to survivors of sexual assault. My colleague Gobina Nagaraja is in charge of the Newcomers Project as well. So we have some specific legal information that helps people who are new to this province. And of course, we're also always working on updating our publications and providing these information sessions. The information for how to call the phone line I mentioned is here on this slide. So if you want to get in touch with me in the future, please certainly do feel welcome. Now, I mentioned legal information versus legal advice. Now, legal information includes a lot of things that can be really, really helpful, but it's important that we not cross that line into giving legal advice, mainly because, of course, the Law Society regulates lawyers providing legal advice, and we at PLIAN we're not insured to give legal advice. We only provide information. But information includes a lot of stuff, so we can indicate all sorts of clear-cut laws, for example, that are in legislation. We can discuss possible options that you can have for making a legal choice. We can discuss case law, but I can't tell you exactly how to complete forms or applications. I can't tell, well, I can talk through what the form is looking for help with. Happy to help as much as I can, but I can't tell you what's the best option for you. I can't give you an opinion on how best to proceed. We also operate a lawyer referral service. So if you do need advice, I can refer you to a private lawyer who works in that area of law, who would be able to give you a half-hour consultation for $40, and that includes tax. So you would be able to get some legal advice in that way. You have no obligation to hire them after that, but that's an important service that we provide as well as organizing this referral service. So now into the substance of what we'll talk about today, wills and estates. Now, a will is a document that governs what will happen to your property after you die. Now, obviously, there's a lot of formal requirements for making sure that this is a valid document. In Newfoundland and Labrador, there's a piece of legislation called the Wills Act, which sets out some of those formal requirements. So a will needs to be in writing. You can't make a video will, for example. It needs to be a written document. It can be either typed or handwritten. If it's handwritten, that's called a holographic will. It's such a fun term, but it's not that exciting, really. It just means it's all in your own handwriting. And if it's a holographic will, you don't actually need to find witnesses. It can just all be in your own handwriting, signed by you, and you should have the date written on it as well. Now, in order to make a valid will, you need to be at least 17 years of age. And if your will is typewritten, so not a holographic will, you need to sign it while you're in front of two witnesses. And both witnesses must be present at the same time you sign the will. So you can't like prepare it, sign it, and then bring it to someone else. The point of the witnesses is they're attesting to the fact that you are signing it yourself. They're seeing it happen, and they could be called upon later to testify to that when the will is being brought to court, if it's being probated. So you need to be, yeah, so there a little bit of work goes into organizing the execution of the will, and those formalities are quite important. Because the overarching consideration is that you need to be making your will free from pressure. You need to be making a free choice about how you're distributing your property. It's your choice, no one else's. And you need to understand what you're doing when you're signing that will as well. And so that's what legal capacity refers to, is that understanding of what you're doing. Now, capacity is a really interesting and important question, especially for seniors and for people who are potentially dealing with Alzheimer's or dementia diagnoses in their lives. Now, in order to write a valid will, you need to understand what you're doing, remember and understand what it is that you own, what it is that you're distributing under your will. you need to understand who you're giving those items to, who you're excluding in your will. Now, capacity, it's not necessarily as though people wake up one day having capacity and then the next day they don't have it. It's not like there's one clear bright line in a person's life, I suppose, is all I mean. So sometimes someone might have legal capacity on the day they are writing a will, but maybe not have it when it's time to sign it. And so capacity is a legal question. When it comes to drafting a will, I definitely think that it's best for people to hire a Newfoundland lawyer to draft it and help them organize it, partly because of all these considerations. So these capacity issues, I think, also highlight how important it is to make a will sooner rather than later. It's best to get organized, even if it is obviously, wills I certainly understand are a stressful thing to think about. Nobody likes to think about what will happen after they die, of course, but a will is something that can make sure that things happen the way you want rather than change from the default. And I'll talk about what the default is a little later. So here are some important parts of a will to include. The date, which is very important, of course, to prove which will is the correct one to use. Excuse me. Of course, if you have multiple wills, the later one is the one that would prevail, because you're allowed to change your mind about what you wanted to happen with your property after you die. Now, it's important to name the executor as well. The executor is the person that you're designating with the power to handle your money and assets after you die, the person who has the responsibility to execute your wishes. And then the gifts under the will. So what do you actually want to happen to your property? You might have some small gifts that you want to distribute to certain people, maybe a favorite ring to a particular niece, or a collection to a certain person. But there's also monetary gifts, like a certain amount of money, and then residuary gifts. So the residue is a very important word in a will. That's what happens to anything that's left over that's not specifically allocated. What will happen to that residue? Is it to go to a certain person? Is it to be split between a couple people on certain percentages? So there's lots of different ways of organizing exactly how your property is to be distributed. So an executor can be any person or persons. It can also be a trust corporation. I believe Scotiabank or Scotia Trust has a section that sometimes acts as executors. An executor essentially steps into your shoes and they handle all your legal and financial matters once you die. So it's their role to file your final income tax return, to maybe keep your business running if you have one, and file lawsuits if they're necessary, to pay off your debts if you have them, okay? Executors are obligated to act in good faith in handling your affairs. So that, for example, that includes making sure that you don't lose money unnecessarily. They need to do things in order to, their overarching consideration needs to be sort of maximizing the value of the estate in a lot of ways and implementing your wishes. So they shouldn't, for example, just sell your home really quickly or lower than market value just to save on insurance or heating. They need to try and maximize the value of your house. They need to keep your estate's best interest at heart in the way they're acting. Now, when you're picking an executor, there's logistical considerations, practical considerations that you might want to keep in mind. It doesn't, like the executor doesn't necessarily have to live in Newfoundland, but they're going to have to deal with the Newfoundland courts and registry of deeds in all likelihood in order to do their job. So you might want to consider choosing an executor who lives in the province, but of course it's completely up to you. You might want to consider like the professional background of the executor. So often people pick one of the beneficiaries in their will to be the executor. But often the beneficiary is one of their children. It's obviously often a bit awkward to pick one specific child, but maybe it just comes down to, well, you know, this child works in accounting, that probably they could handle this particular administrative task. That might be something to consider, but ultimately the choice of executor is up to you. It's a big responsibility. They do get a little bit of compensation from your estate for acting as executor once it's all complete. That's something that a judge has to sign off on, but there is a small pecuniary benefit to being an executor, but it's a lot of administrative work for sure. When you're drafting your will, you might want to consider giving the executor, like explicitly giving them the power to hire professionals to help manage the estate, like lawyers and accountants and financial advisors. That can reduce the stress on the executor. It could be really helpful. And another thing might be directing your executor to provide certain information to beneficiaries and the family, which can perhaps prevent fighting and unnecessarily expensive court applications, which of course can really reduce the value of an estate as well. So what are the different types of gifts under a will? There's personal property, so any personal item. There's real estate and land. So as opposed to personal property, it could be your family home, it could be a cabin, it could be a piece of land. It's usually important to think about the specifics when it comes to real estate, because of course it's difficult to divide a piece of land oftentimes, or like it really changes the value of it. So you might want to, so some people direct it to be sold and then the proceeds divided if they want people to share in it. But there's lots of ways of organizing it. There's lots of options. When you're trying to give monetary gifts to certain beneficiaries, you might want to consider giving it on a percentage basis rather than as a specific dollar value. So that's simply because if a specific dollar value turns out not to be in the estate at the time of the probate, then you run the risk that that beneficiary actually doesn't get a gift at all. So for that reason, a percentage basis is more likely to, actually be implemented. Would be one way of considering it. The residuary clause, I mentioned this already, but essentially anything that isn't specifically disposed of in your will, you might, I leave the rest and residue of my estate to be divided among these three people or their heirs. If you don't include a clause of that nature, like referring to the residue, then anything that's left over would be distributed according to the Intestate Succession Act. So this is another piece of legislation. I mentioned the Wills Act already, but the Intestate Succession Act is how, excuse me, the Intestate Succession Act determines what happens to property that isn't disposed of by a will. So if you don't write a will and you were to die, what happens to your property is determined by this piece of legislation, and it also applies to the residue if it's not referred to in your will. And the basic structure of it is, depending on what relatives you have that are alive at the time of your death, they share in your estate at different percentages. So if you're legally married at the time of your death, your spouse will get either a third or half of your estate, depending on how many children you have. Then your children will get shares of what's left over after your spouse. Now, if you don't have a spouse or children, your parents, if they're alive, would be the next. It proceeds on in terms to progressively more distant relatives, depending on who is in your life at the time of your death. So now, of course, the Intestate Succession Act, it kind of is a good default, I would say, in a lot of ways for people who haven't written a will. But like if I were to die tomorrow, like my husband would inherit everything, which is exactly what I would want. So fine, I might not might not need a will. But of course, if he were to die first, well, then my mother would inherit. But of course, your wishes might be different from that. And a will gives you the power to decide exactly who should take care of your property and be your executor once you're gone. Now, there are some other considerations here too. You can't necessarily leave literally everything you own exactly how you want, because sometimes there's other obligations that supersede your wishes when it comes to certain types of property. So for example, matrimonial property, your spouse, your spouse has certain rights to property that was accumulated during your marriage. So the Family Law Act lets a spouse apply to court for half of those shared assets when a spouse dies. And now, if your will left your spouse less than that amount, then the court will override the will and give your spouse a larger portion. When it comes to the matrimonial home too, if you're married and you own your home, there's like an automatic joint tenancy, it's called, in terms of who owns that house. Now, this may not apply for couples that are common law partners, but if you're legally married, you do own your house jointly with your spouse, regardless of what it says in the title. So this is another really important consideration. If you have a common law partner, it becomes all the more important to write a will, because your partner doesn't necessarily have a lot of rights to your property if you don't have a will. Now, if you own stuff together with your common law partner, they should be able to take it over. But if something is just in your name, your common law partner doesn't have any particular rights to it, unless you wrote a will to that effect. Joint bank accounts are another important thing to consider. If you and your spouse have a joint bank account, often the spouse can just go ahead and take over that account to access the jointly held money. But it can get a little more complicated, particularly when you have a joint bank account that's held with your child. So for example, some people, as an alternative to enduring powers of attorney, just add a child as a joint bank account holder. It depends. So if that's your intention, if it's just for day-to-day circumstances, day-to-day expenses, that money may not automatically be held by that particular child after your death. It may be supposed to be divided as your will would put it. Now, in any case, it can get complicated. So just be careful to think about joint bank accounts when you're drafting your will, I would say. A few other considerations. If you get married, that typically voids your will. Okay, so that would not be a valid will anymore if you get married, unless you take steps to ensure it is still valid. Divorce and separation is different. It doesn't void your will in the same way, but it often is a good time to update one, of course. Now, what if you write a will and one of the beneficiaries that you name in it dies? So sometimes, if the will isn't updated, the gift might be canceled and then their gift will become part of the residual estate. But of course, it depends on how it's drafted as well. So if your will says that it's to be passed on to their heir, then they might take it. Again, this highlights the importance of careful drafting of your will, maybe talking about it with a lawyer. So all these things can be quite relevant. Now, there's a few common misconceptions about wills and estates. Oftentimes in mystery movies, there's a dramatic reading of a will event, revealing various motives for what happened. Those don't happen automatically, okay? If you want there to be a formal reading of a will event, you would want to direct that one be organized in your will, okay, as part of your wishes. Sometimes, I guess, certain executors may decide to do so, but it's not something that happens automatically. I think that's a common misconception. An executor too, I mean, so this is especially like before the person dies, before the testator dies. Sometimes an executor is aware of where the will is being stored or whatnot. And the executor is supposed to keep it private, okay? It's your document. Now, once a will is submitted to court for probate, it does become publicly visible at that point, but not all wills are submitted for probate, but they often are, and at that point they do become visible to the public. Common law relationships, I already touched on this. Really, common law relationships are just more complicated than legal marriages. So the importance of writing a will is just much more heightened for those types of relationships. You don't need a justice of the peace or a notary to witness your will or be a part of your will in any way. Okay, the witnesses can be anyone at all. And dementia and Alzheimer's, I talked about this a little bit previously. A diagnosis of that doesn't necessarily mean that you can't make a will, but I mean, if someone really doesn't understand what they're doing, of course, that will be an obstacle. So again, this just highlights the importance of organizing these things sooner rather than later. Now, why have a will? Well, it helps you maximize your estate's value, okay? And probably more importantly, taking stress away from your family and friends, just adding a lot of certainty about what you did want to happen, and having that available can really reduce the stress for the people who are left behind. It also gives you autonomy. It lets you choose who handles your financial affairs and choose the manner in which they're handled. Some people say, well, I really don't have any assets, so I don't think I need a will. It doesn't really matter. I mean, fair enough to a point, but you might inherit something later in life. Your circumstances might change. Someone, like if you died without a will, someone needs to be able to access your money in order to do certain administrative tasks, even if it's just as simple as dealing with Revenue Canada and canceling certain subscriptions. Like those are duties that will have to be handled. So sometimes designating someone specifically can just make that whole process easier. So next on to the different, the other type of documents that we're going to discuss today, the powers of attorney. So as I mentioned at the beginning, these are documents that enable someone to make decisions about your property while you're still alive, but while you aren't capable of making those decisions yourself. So for this type of document, there are formal requirements again. You need to sign it in front of just one witness. This time it comes from the Enduring Powers of Attorney Act. There's another piece of legislation. You need to have legal capacity when you're drafting the Enduring Power of Attorney. That's important. It doesn't come into effect until later. So oftentimes there's a provision in the Enduring Power of Attorney document explaining how your capacity is to be assessed. So if a doctor is willing to state and write a letter saying that you lack legal capacity, then that document gets activated. An enduring power of attorney can be revoked. You are allowed to do that if you want to change your mind about who you're naming as your attorney. Now, who can you name? You can name a person. You could name multiple people if you wanted to. You could name a trust corporation if you want to. There's different pros and cons to different methods. Sometimes people think it's better to have multiple powers of attorney, but I guess I tend to think there's a lot of downsides to that as well in terms of creating uncertainty and possibility for fights. But you can have a lot of specifics in terms of what you want your attorney to do as well. So you can restrict them to certain types of your property. You can instruct them on not selling your home, for example, if you want that to be left to a certain person under your will. You might want to require the attorney to make financial reports annually to your children or your family. These are, yeah, so that again can sort of reduce the potential stress. If you own a business, it might be particularly valuable to have a power of attorney. So who will handle things while you can't? You might want to have an attorney in that case. Fishing or land licenses, that can be another example of people who might strongly want to consider having a power of attorney in place. Selling a house, just another example, and alternate attorneys. So you might want to name a backup attorney if the person you prefer is not available. It might be nice to have another specific backup person named. And why have power of attorney? It's insurance for when you may be in need. You can choose exactly who you want. And again, there's lots of good reasons to get one in place sooner rather than later, is particularly for reducing the stress on your loved ones. Banks can be actually fairly difficult to deal with, oddly enough, even if you do have things organized. I've had a couple calls from people who, so if you don't write a power of attorney and someone loses and you lose capacity, so in order to get access to your money, someone would need to apply to the court to get what's called letters of guardianship. And oddly enough, the banks don't really seem to understand letters of guardianship, even though they come from the court. They're equally authoritative to an enduring power of attorney. But it's very odd. I've just had a couple calls lately from people on that topic, so that's why it's on my mind. So best to get things organized with a power of attorney, and maybe even talk about it with your bank and have it on file there in advance, such that your attorney will be able to deal with your affairs and pay bills for you when the time comes. Now, the attorney, they can't do just whatever they want with your property. They can't, go on vacation to Florida with it, but they can often do a lot of stuff that they deem to be in your best interests. They have to pay your taxes and bills. They can hire professionals to help manage your affairs. They can sell your house unless you put a restriction to the contrary in your enduring power of attorney document. Now, again, back to the banks. Sometimes banks have their own power of attorney forms on file. But they may or may not actually do everything you want them to. It may only deal with certain things that are in that particular bank. So I would caution you to talk to a lawyer about the particular power of attorney that your bank gives you before you sign that and consider the whole matter closed. You might want to think a bit more holistically about everything you own before deciding that that covers everything off. So having a power of attorney can be really beneficial when you're a lot older, if your mobility declines and it's more difficult for you to do your own errands. If there's more extreme scenarios too, if you're in a coma or you have dementia or Alzheimer's, these are moments when having someone manage your financial affairs can be really beneficial to you and your family. And it lets you choose who would be the one to help you in that time of need and how they should handle your finances. Again, it just goes to autonomy. So finally, just a few brief considerations about dealing with homes and land, real property, okay? And this is just going to be the final topic before I get into questions. Real property is land and any buildings on it. There's different ways that it can be transferred to people. It could be leased, it could be granted by the Crown, it could be bought and sold, you can gift it. And not all land is as valuable as people think it is, I would say. It depends on various factors. We all understand the real estate market has its ups and downs in a lot of ways. Newfoundland is a little unusual in that our registry system for land title, it's not mandatory to do so, but it may be needed to complete a sale of the land. Why register your land? so people know what you own, and it can be a lot clearer about that your title is, this is, so organizing, being sure that people know that your title to land is good is best achieved by having things registered. You do need to, there are fees associated with it. It's based on a percentage of the value of the land. So if you have a purchase and sale agreement or a will, those are mechanisms that land can be transferred by. You can't really transfer land by oral agreement. So if you're speaking, you really need to write it down to transfer land. Now, when it comes to capital gains, so this is relevant if you have multiple properties. So if you were to have a cabin or some other like piece of property, maybe that you inherited from a family member, when that is transferred, there will be a tax based on 50% of the increasing value of the property from when you acquired it. So there's a little mathematical example here on this slide that you can look at if you're interested. So that's all the substantive stuff I wanted to present, and we can get into the questions now. So there were a few things. Let's see, there's lots in the chat here. So let's see.
I can help you with that if you'd like.
Sure.
Okay, excellent. Because we also, so thank you very much for that, Kirsten. If you want to stop sharing your screen, then maybe we can all see each other.
Okay.
Wonderful. Okay, so with regards to questions that currently are in the chat, can you highlight the difference between a power of attorney and an enduring power of attorney?
Sure, absolutely. So a power of attorney is a more general term. Let's say that I'm selling my house and I'm just going to be out of the province at the time of the closing date. I might want to make sure the sale can proceed without me, but of course I'm not on the spot to sign the documents. So I could give a power of attorney just for that issue, to sign legal documents to maybe to my sister who's still in the province. So you can have a power of attorney for all sorts of scenarios. An enduring power of attorney is a specific one that refers to one that will enable someone to generally manage your property with whatever restrictions you put in place once you lack capacity. So an enduring power of attorney is about that planning for a lack of capacity. A power of attorney might be, it could refer to different types of powers of attorney, but you want to be specific to have an enduring power of attorney if that's what you're trying to plan for.
Perfect. Also from Callista, after the death of a spouse, do you need to update your will, or is the one you have okay? And they, in brackets, they had mirror wills.
Another good question. I would say it depends on how your will was drafted. That many wills like that are designed to be to not necessarily require much updating. So but it does depend. And I guess I would say if you're in a scenario like that, you might want to bring the will back to your lawyer and ask about if there's a need to update it. But I mean, if your wishes haven't changed, and the will provides for who inherits if your spouse is gone, well, you probably don't need to update it, but it's it really depends on how exactly the will is drafted.
Great. From Joseph Noseworthy, are online free will forms valid and legally acceptable?
They may be, but because the law of wills and estates is provincial, and if you are downloading a will from like a will form from somewhere else in the world, it may, like the risk of using forms of that nature is that the wishes expressed in them aren't going to be enforced in the way that you're imagining. Getting specific legal advice in Newfoundland is really the best way. again, I guess I would also mention too, like, if you're using a pre-printed form, do make sure to pay attention to those formal requirements from the Wills Act at a minimum. But I guess I would always say it's preferable to have a will drafted in a custom manner by a Newfoundland lawyer. That would always be the preference.
We have some questions that people provided when they registered as well. So if you're okay with that, I'm gonna.
Absolutely, yeah.
1021. And if anybody wants to, has any additional questions that they want to throw into chat, please feel free. We'll keep an eye on it. What are the implications, or are there none? Sorry, implications on not having a will if you have kids or teens?
Okay, so absolutely, those are, it's, if you have children, that's another good reason to be sure to have a will, and minor children especially. So thinking about who will care for them is absolutely something that you can address in your will. You might want to, so for example, sometimes people organize it such that their property and their money is left in trust for their children, and they name a trustee who can pay out certain amounts to the child's guardian for their for their expenses and their upbringing. That's not uncommon at all. Now you can name the person that you would hope to be the guardian in your will, but bear in mind that it's not a complete guarantee. The court does have the authority to like make other orders depending on what the child's scenario is at that time. So there's only so much control you have in that scenario, but you can certainly do a lot of planning to make things easier. And you can name the person that you think would be the best guardian for your child. You can name a backup even, but the amount that those wishes are guaranteed is a little bit, I guess I would say it's less of a guarantee that those will be executed than other things, because the scenarios of those people might change. It's something that, but it absolutely, I guess I would say it really is a good thing to update a will and have a will in place. If you have children, then those are certainly, there are some specific considerations that you might want to bear in mind.
Anita just asked if there's a required fee to pay an executor, and if so, how much should that be, or how is it determined?
Sure. There is a small percentage of your estate that the executor can claim as a fee. Okay. It depends on how much it is. I guess it usually ranges from like 1 to 5% of the estate. Sometimes like the court has to sign off on how much the executor is claiming as their fee. Typically the amount, the percentage varies based on the size of the estate as well, how much work is involved in doing it. But yes, there is a fee that the executor can claim, and that comes out of your estate before the gifts are distributed.
Okay. Danica, Megan is from an LAD, and she wants to know if she can ask a question. So maybe you can assist.
Yes, Megan, you can go ahead. Hi there, my name is Megan, and I'm just curious. So with seniors who are deaf, it's a little different because they require an interpreter to go with them. For example, there's a lot of misunderstandings that happen where English is not their first language. So if you go to in the family situation, maybe a friend or someone is interpreting, but that is no good. You need a professional interpreter. For example, Danica here today is a professional interpreter, just because things won't get lost in translation, we'll say. So it's really important to have an interpreter. So I guess, is it possible for the deaf client to be able to, to pick an interpreter for seniors NL? I'm just wondering if that's something that is can be provided, just to make sure that we have an interpreter in place for seniors who are deaf, so that the communication doesn't get lost.
Sure. I guess I would say from a legal point of view, having I would guess the interpreter would probably need to sign some kind of affidavit to attest to their professional interpretation. That would probably be something that would improve the likelihood of the will, well, of course, being well understood and being enforceable later. But I mean, certainly is a really important and interesting scenario that you describe. So I would say a person who is deaf should consider hiring a lawyer, like to write their will, and have them sort of address some of those issues in the drafting. Absolutely.
Is that okay, Megan? Good.
Yeah, it's fine. Like, I think I'd like to have more discussion on it later, though.
Okay. What I might suggest in that case, Megan, is to reach out to PLIAN and Kirsten directly after this presentation, or whenever you guys have available time to pursue that further. Is that okay, Kirsten?
Sure.
Okay, Megan?
So is it okay if I email? Might that be a good idea?
Yeah, absolutely. Absolutely.
Fantastic.
Okay, wonderful. Thank you so much.
Thank you. Irene asks, when you refer to a handwritten will, does this mean you can just take a piece of paper, write your wishes, sign it, and it will be valid?
I mean, essentially, yes, to a point. Okay. It depends on if your wishes are clear and enforceable and match what's actually in your estate at the time of your death. But ultimately, I guess, yes. There's a famous example that everyone enjoys in law school of a farmer in Saskatchewan who, well, he realized he was dying as he was out in his tractor on the fields. He had some kind of horrible accident, but he managed to scratch in the door of his tractor "all to wife," and this was enforced as a valid holographic will, leaving everything he owned to his wife. So like, I would say yes, like writing down your wishes. It's probably like, if they're different from what the Intestate Succession Act would have, like, yeah, it's better than doing nothing. But again, depending on, like, if your wishes become more complicated, the value of having a lawyer draft it and plan for different contingencies becomes higher. So, but yeah, I mean, ultimately you can absolutely write your own will in your own handwriting. And as long as your executor can find it, then, you know, that should be enforceable to whatever degree your wishes are intelligible by the court.
Excellent. I'm going to go back to questions early on. Can a person who has the capacity to make their own decisions, this might be the same, can a person who has the capacity to make their own decisions handwrite a letter outlining their health and financial decisions be accepted as EP, an enduring power of attorney, as long as the letter is witnessed? Was that clear?
Sorry, I think I didn't quite understand that.
I'm going to read it again. Can
okay.
a person who has the capacity to make their own decisions handwrite a letter outlining their health and financial decisions and have it be accepted as an enduring power of attorney as long as the letter is witnessed?
You do need to have it witnessed. I guess in principle, yes, you can have it handwritten. You can do it yourself. I guess I would say, again, the more complicated your property is, the more complicated your wishes are, the higher value there is in having custom drafting. I would also say with an enduring power of attorney, at PLIAN, we have a publication called the Legal Planning Guide that actually has an example of an enduring power of attorney, and that could make the drafting easier. And I would be, if you get in touch with me, I'd be more than happy to send a copy of that publication to you, okay? So like, yes, it is certainly quite possible to draft your own enduring power of attorney if that's what you wish. You need to comply with the formal requirements and have a witness. But yeah, I mean, it absolutely is possible to do it on your own.
And I'm just going to note that we've put your email address into chat, and
Sure.
everyone, you're willing to share these slides with everyone. If you are, then we'll send that out to people.
Yeah, that's fine.
And your contact information is in there as well.
Yeah.
Okay, how do I shop for an enduring power of attorney as my trusted power of attorney passed 3 months ago?
So to find someone to act as the attorney, it really comes down to what your social network is like. It's completely up to you who you would choose. There's no one size fits all answer. It really depends on your scenario, and it is possible to get certain trust companies to do it. But I guess I don't really have much that's more specific to say on that. It really depends on your preferences and your scenario. I'd say some of the same practical considerations for choosing executor apply. Someone who's on the spot in Newfoundland could be beneficial. Someone who's just able to access your documents and wherever your property is held. It's probably likely to be more convenient that way, but it's truly just a choice for you. It depends on what your friends and family are like.
Callista asked, could you specify in your will that you want your executor to have a sum of money for being executor, and would this case matters amounts? Sorry, I'm not quite understanding this. Could you specify in your will that you want your executor to have a sum of money for being executor, and would this case matters amounts beneficiaries and alleviate the need for the executor to submit a claim for compensation?
I guess it could. You'd want to be, I mean, it might not, like if you're choosing a sum of money that's way less than what they would get from the court, I mean, they would probably still apply to the court to get that larger amount that they're entitled to. But I guess it could make things easier. It's also, like, bear in mind, it's not uncommon at all for the executor to also be a beneficiary of the will. So depending, I guess in principle, there's nothing to stop you from sort of drafting it that way and adding like an extra bit of compensation for them. But I guess I'm not sure it makes things less administratively burdensome. Like it might, but it might be something to talk about with a lawyer drafting it.
Speaking of, could you talk a bit about the price of fees for wills, POAs, a ballpark?
No.
Different lawyers charge different fees. It usually depends on their seniority, like how long have they been practicing. I guess what I would say is with wills and powers of attorney, since lawyers with experience are usually able to pretty safely predict their fees for this particular type, but ultimately most lawyers charge by the hour. So it depends again on how complicated your will is. It's like, I guess I wish I could be more specific, but it really just depends on your lawyer. It could range, it could range quite a bit. I would guess like from a few $100s to a few $1,000s. It just depends on how complicated your wish estate is and how senior the lawyer that you're talking to is. So I would say that you should discuss fees up front with any lawyer that you're considering hiring for a will. And it's, as I say, like this is a type of legal service that usually the lawyer will be able to predict and give a flat fee for, but different law firms have different practices. So certainly inquire early when you're talking to a firm.
Seniors and I'll just made a note in chat that it's critical that the person you choose to be your executor and or your enduring power of attorney is someone you trust completely. Seniors are sometimes coerced into naming someone who will take advantage of an opportunity to financially abuse the senior. So I think the message is
sure. No, that's a great point. It's just it's a very personal decision and important to reflect carefully when you're choosing someone to act for you in this regard, because it's your property and you deserve to understand what's happening and why.
And Irene, you asked, when you talk about the power of attorney, you're referring mostly to financial decisions, property for sure. Does power of attorney apply to healthcare decisions as well? And the answer is no, and that's the Advanced Healthcare Directive. And that's, we're going to have in the very near future 2 sessions on the Advanced Healthcare Directive specifically. So stay tuned to your email. Kirsten, a couple more questions. Do you have time?
Yeah.
Cool. Wondering how often a will and accompanying document should be updated.
In short, I would say whenever there's a big change in your life. If there's so like a common time to update a will would be after the death of someone named in it, or after the birth of new people you want to include, so often grandchildren, or maybe after a divorce as well. I would say would be another moment where it would be important to update a will. But there's no one answer. You might want to look at it every few years and think about whether stuff in your life has changed, whether your wishes have changed. But there's really no one answer. It depends on if your life is changing very much.
Okay, great. If I have an outdated will, how do I discard it?
You don't necessarily need to do anything specific. You might want to destroy it if you don't want it to cause confusion. But if you just simply write a new will, that supersedes the old one, as long as people find it. And so I guess the thing is, you want to make sure that your latest will is retrievable by the executor. Actually, that's something I wanted to mention. If someone in your life dies and you are looking for their will, essentially you just start by looking through their papers. If it's not in their house, it's probably, it might have been left at the lawyer's office who drafted it. So if you know who their lawyer is, you might want to inquire there. If you don't know who their lawyer is, oftentimes you can actually ask the Law Society, which is the professional body that regulates lawyers, to conduct a search for a will. So they'll send out an email to all their members asking for information on the will of the person that just died. But I guess I mentioned that to say, if you're the one planning, you may want to make sure your executor knows where to find the updated will. So again, just to avoid confusion, you might want to destroy old wills so they're not found and mistaken for the latest one. But there's no formal process for doing that.
Okay. And I think you've answered this one. Is a handwritten will a legal and binding document, and does it require a witness? That was early on.
Again, I mean, it's like, yes, it can work. No, you don't need a witness under the Wills Act. That's called a holographic will. But there's risks involved with holographic wills in terms of if you have more complicated wishes, those are, there may be issues enforcing them.
Okay. Someone did ask, and I think maybe you've answered this too, is doing a will on legalwills.ca okay to do? It's cheap.
I mean, I guess I answered that one already. I'd say
yes,
no.
you did.
Yeah.
Because of the Newfoundland required specifics.
Yeah.
What assets should you list if your spouse has passed and your children will be your beneficiaries? I think you've covered that off as well. Is probate required?
Not necessarily. Probate is a process by which the will is sort of authenticated by the court, and the executor gets letters of probate from the court that will enable them to deal with anyone who has your property and give them the authority to manage it and distribute it. So I would say it's not required, but it becomes more likely that it's necessary the more stuff you own, especially if there's land. If you have land or a house and that needs to be sold, your executor probably will need to apply for letters of probate in order for that sale to proceed. But there are times when probate is not required. If you, for example, like if your assets are just a joint bank account that is being left to the executor should probably, or should be able to just bring your will to the bank and get it. But I would say it just depends on what assets are in your estate at the time of death, is what it comes down
Okay.
to.
Wonderful. Okay, just one other one. Is it possible to do a joint will?
So it's an individual decision. Sometimes married couples write wills that are mirror images of one another. That was referred to in one of the earlier questions, meaning they're leaving everything to one spouse, the other spouse would leave everything to the other one, and then they have the same backup beneficiaries. However, typically those are not, like if you died first, your spouse is perfectly free to update their will, typically. So it would be something like if you want your spouse to really promise you that they're not going to update it, you would need to address that with them. But a will is ultimately a manifestation of your individual wishes.
Okay. And our credit card balance is erased upon death, i.e. life insured.
Sorry, could you say that again?
Our credit card balances erased upon death, i.e. life insured.
No, I mean, your credit card debts are a valid claim against your estate, okay? So your credit card company has a perfect right to come to your executor and say, I want this to be repaid. But what they don't have a right to do, let's say that you actually do have no assets, only liabilities. You sold your house long ago, you've spent your money, and you have a bunch of credit card debt. Your credit card company can't bother your children for them to repay, like, because debts are not inherited in the way that property is. But if there are assets, then yes, your debts are supposed to be validly paid. So it would be up to your executor to deal with that out of your assets.
Excellent. Okay, I think what we'll do, it's almost 10:45. So thank you, Kirsten, very much for all of your
Meg, there's
information.
one more question, Meg.
Oh, yep.
Deborah asked, do you have a list of lawyers who specialize in this type of law in Newfoundland?
I wouldn't say I have a list, no. If you're looking for a referral, you can certainly get in touch with us to avail of our lawyer referral service. But there's not like a list of all the lawyers that do wills and estates. I would say that wills and estates, like most firms, have some capacity to do it. But if you do want a specific referral, please get in touch.
Okay.
Thank you.
I think that's it. Excellent. So thank you, Kirsten, very much. Really appreciate it. Thank you very much, Danica. Appreciate it. And we'll be back to everyone with slides and recording as soon as we have that updated or loaded up to YouTube. And we'll also be back to you with our next Let's Talk as soon as we have that finalized as well. Thank you for joining us.
Thank you for organizing it, and thank you for inviting me, Meg.
Glad you were
It was
here.
a pleasure.
Bye, y'all. Have a great day.
Thanks.